I'm Ken Wells, your host on toyoursuccess.tv, and today we're going to be talking about family law, and more specifically we're going to be talking about family mediation. And joining me today is John Schuman from Devery Smith Frank, and John is a family lawyer and he also heads up the family law group at Devery Smith Frank. So John, welcome.
Thank you. I'm glad to be here.
A lot of people, when they're going through some family law issues, and these are things that could be divorce, could be separation, child custody, those kind of things. Everybody hates the court process. And it seems like more and more people are leaning more towards family mediation. So that's what we're going to talk about today. So I'd like to start off by saying, can you explain what family mediation is?
Well, family mediation is just that. It's an alternative to the court process. And you can choose to do family mediation instead of going to court, or you can choose family mediation while you're in court and you want to have a sort of more productive discussion of what the issues are and try to resolve things out of court. Either way, it's going to be quicker and less expensive than court, but you and your spouse have to agree. It's a voluntary process. So you can't be forced into it like you can be forced to go to court by your spouse. You have to agree to go to mediation, and you have to agree that on the person who's going to do the mediation. And once you are there, it is still a voluntary process in that you are allowed to leave at any time, but you're there to work on coming to an agreement together and have the mediator help you in coming to an agreement. And that's what family mediation is about, instead of having a judge imposing an agreement.
Okay, so is what happens in a mediation, is it binding in a court?
That's a common question. And what happens in mediation is, well, going to mediation is not binding. You can't be forced to go to mediation. And until you come to an agreement at mediation, nothing's binding. It's a confidential process. Nothing you say in mediation is supposed to be released unless you agree that it can be released before you go to mediation. So it's a confidential process, and if either side walks out, they walk out. The mediator does not have the ability to impose a settlement. The mediator can suggest a settlement or have discussions with you about how to resolve things, but what the mediator says is not binding. And once the mediator is done, and if you've come to sort of a framework for how you're going to resolve matters between you, the mediator writes up what's called a memorandum of understanding. And that's sort of written down what you agreed to. But even that's not binding yet, because memorandums of understanding are not binding under the Family Law Act. Only a separation agreement is binding. So what you need to do is you need to go and convert that memorandum of understanding into a separation agreement. And once you've agreed to the separation agreement, which has the terms you agreed to at mediation, once you've both signed on the dotted line, or it's actually not dotted, it's flat line, at the end of the separation agreement, then it's binding and it can be enforced by a court.
Okay, so why do individuals stick with the mediation process?
Well, they stick with it because it's less adversarial, it's less, you're not fighting with your spouse as much, and it's often much quicker than court, because you can get in to see a mediator in, probably 3-4 weeks. But your first court date can be 6 weeks down the road if you're in a place where they have quick court dates, or it can be months down the road. So it's much quicker than going to court. And it also allows you to tailor the result that you and your spouse want. If you go to court, the judge decides, and the judge decides what they think your family should do, and that can be totally different from what you and your spouse would want. But if you go to mediation, you and your spouse sit down and you work out the terms together, and you work out the terms that you want and decide what's important to you and what the resolution that's important to you. And that way you have complete control over the process, which you don't in court. And so you come up with agreement that instead of an imposed settlement, that reflects your values and what you want to see and what's important to you and your children, instead of what the judge thinks is important to the judge.
Okay, so if I go for mediation services, do I still need a lawyer?
Yes, you do. You still need a lawyer. As I said, you want to come to, at the end of the day, a separation agreement. And what happens in mediation is not binding until you get to a separation agreement. And in order for a court to enforce a separation agreement, the court has to know that both sides understood what they were signing at the time they signed the separation agreement. And what courts say they need to see to know that you understood the agreement, or any contract really, is you need to have talked to a lawyer about that agreement and the contract you signed before you finally signed it. So you do need to speak to a lawyer to have a binding agreement at the end of mediation. There are also a number of good reasons to have a lawyer involved, and before you go to mediation, you want to know what your settlement range is. if you read this book called Getting to Yes, they talk about your batten and your what. Now, what's the best result you could ever hope for if you went to court? What's the worst result you could ever hope for if you went to court? You're not going to know that unless you talk to a lawyer. And so you know where you should settle for, and you also have a bit of idea of what the rules are and how the law works and applies to your situation. If you go to mediation without speaking to a lawyer first, you're going to have no idea what that is. And there's a lot of little loopholes and things, and especially on the financial issues, that you can get yourself into trouble, and you want to avoid those. So having a lawyer will really help you, and often helps get the mediation done more quickly.
Okay, so does the lawyer actually sit in the mediation as well?
The lawyer can sit in the mediation as well. And if you have a power imbalance, which means that if you're afraid of your spouse, then the lawyer is obviously a good thing to have there, because the lawyer will help correct that power imbalance. It's not, the lawyers can stand up there and be supportive to you and keep you from being bullied. So if you've got a power imbalance, you should absolutely have a lawyer with you to sort of correct that power imbalance. And you should have a lawyer who's able to correct that power imbalance as well. So someone who's going to stand up for you. You can also have, when you have negotiating kids issues, a lot of those are really logistical things. I mean, you talk about the best interest of the child, but if you're going to mediation, chances are you and your spouse have come to some idea of a lot of the big picture items. But when you get down to whether your child plays soccer or goes swimming, and who drops off and who picks up, and who's going to have what time on birthdays and all that sort of stuff, it's really little details. And if you get a good mediator, and usually there's social workers and psychologists who are child psychologists who do this all the time, then that person will be really good at doing the details. And because there's no real magic to that, like I'm not going to advise you that picking your child up after school at 4 p.m. is better than picking your child up at school after 3:30 p.m. That's not what a lawyer does. They help you with the real legal issues. So working out those logistics, you don't need a lawyer to do. But for financial issues, there's a lot of little loopholes in the Family Law Act and in other family legislation, and there's a lot of little tricks and things that you can really come out the wrong way if you don't know what they are first. And so if you haven't spoken to the lawyer before, and even if you have, and you're in the middle of a negotiation, you might want to have a lawyer there to give you the confidence that you're not going down a path that's going to lead to something bad happening. So having a lawyer on the financial issues is often really, really helpful. And it's also really helpful even at the mediation, because what happens at mediation is you get this momentum going, and you're working towards settlement, you're working towards settlement, you're working towards settlement. And if at the end of that you come to this thing where, okay, now I've got to go away and talk to my lawyer about something, then you sort of kill the momentum. But if the lawyer's there and the lawyer's saying, yeah, this is okay, you can agree to that, you're not causing yourself any problems, or telling you what the problems are, and then you can decide whether you're going to accept them or not. When you're doing that, then the momentum continues on, and you can get to the end, you get that everything written down at the end of the mediation, and you're not coming back, you're not relying on talking to someone else about something and then deciding whether you're going to agree later. So usually having a lawyer there, especially when you're not quite sure about all the issues, can really help you get to a settlement and make you confident when you're there that you've done the right thing at mediation, and then all you're doing after that is writing things up, not worrying about whether or not something's going to come back at you.
Oh, okay, so I guess preparation is key in this whole thing. So if somebody wanted to go through the mediation process, what's really the first step? What do you do first?
Well, the first step is you get your spouse to agree to go to mediation.
Okay.
So that's the obvious one. And, that's an obvious, there's lots of benefits. As I said, it costs a lot less, and you can really tell your resolution to yourself, and it's quicker. But and you also want to pick a mediator that you and your spouse can agree on and trust. You don't want to have someone that your spouse picked that you think is a little bit weird or strange or is out for your spouse. You want to have someone that you think is fair and impartial to both of you, and that you can trust to help you work through the resolution. So that's the first thing. And after you've done that, if you're working on children's issues, then you want to think about, all those things, all the logistics. And, if you see a lawyer beforehand, the lawyer can give you a list of things you need to think about before you go to mediation. So you don't end up in mediation talking to a mediator saying, yeah, I need to think about that, and I'll have to get back to you because I hadn't thought about that. If you go to consult with a lawyer first, they'll tell you these are the things you need to think about and decide what your position is before you go to the mediation, so you don't run into those little glitches. If you're doing a financial mediation, you want to work on getting a financial statement done and all the backup disclosure for your financial statement, and narrowing down what the issues are on the financial matters. Because if you go to mediation, you don't have all your financial stuff prepared, then your first day of mediation is going to be talking about doing your financial statement, who's going to do it, when you're going to do it, and how long it's going to take. But if you've worked with a lawyer or someone who knows about these things beforehand, then you can go in, you can give the financial statement to the mediator beforehand, you can give them the disclosure beforehand, give your partner the disclosure beforehand, say these are the issues between us, these are what the evidence is, because comparing to what will happen in court. And you then say to them, this is where we disagree. And if you have that preparation done in time, then the mediator can come in knowing what they have to focus on, what the bones of contention are, where the money is, where the money isn't, and the mediator can start thinking about how to settle the case even before you walk into the room. And then when you get in there, you can usually get mediation done in one shot if you're prepared. So you can walk in at like 9 a.m., leave at 4, 5, 6 the same day, and have your case done if you've done all the preparation beforehand. If you don't do the preparation beforehand, then you're coming back to several mediation sessions, and that takes you longer. Most people don't want that. They want to get it done.
So most times mediation is done in one day, the majority of times.
It can be done in one day as long as everyone's prepared going in. If you're prepared going in, you can get it done in one day. Sometimes things happen that people don't anticipate, but that's if you're prepared going in, then one day is an absolutely resolvable time. And a lot of mediators will say it usually takes people about 6.5 to 7.5 hours to get to the point where they've come to agreement. And that's what you can anticipate if you're prepared going in.
Okay, so what happens during a mediation if you just can't agree? Right, you get to a point and you're just stuck.
Well, if you're just stuck on an issue, then once again, what happened in mediation is not binding. So if someone walks away, then the mediation is over. If you sit there and you're at loggerheads and you just can't agree on something, then you're going to have someone decide it for you. And now you could obviously come back to mediation after thinking about it, but if you've done all the preparation work beforehand, then you might know that we are not going to agree on this. This is an issue that is that is different for the two of us, and we may not even agree on how the law applies. And if that's the case, then you have to find some way to settle the issue between you and have someone decide for you. Now you can go to court to do that and go back into the court system, take the time, or you can do something called family arbitration. And family arbitration is where you have someone who's not a judge, but someone who you pick, decide the issue for you. And you not only get to decide who's going to decide the issue and how they're going to decide the issue. And that's important because in how they decide the issue, you can set up a very simplified process that's much quicker, much faster, and spectacularly less expensive than court. And in deciding the who, you can decide on a person who is going to reflect your family's values. So a judge, it's a roll of the dice who you're going to get and what they think about your family. But you can pick someone who you think, okay, this person gets our family, and that person will make a good decision that reflects our family. And that's very important to many people because even though it's not a agreed upon decision, at least you've got some control over how it's reflected. One of the best ways to get someone who reflects what the values think is to say the mediator can then become the arbitrator if you can't agree on something, and that can simplify the process and get things done and gives the arbitrator a bit of power in mediation to work things out. But it's important to understand that what happens in mediation stays in mediation, and the arbitrator cannot use that as part of the decision. You actually have a process where you either have like a full trial or you have another process that's simplified, maybe an exchange of documents that you give to the arbitrator, and they decide on that, not based on what happened at mediation. But still, you've been with the mediator and you've talked to the mediator and you've discussed your family with the mediator. When then the mediator will then become the arbitrator, they know what's important to your family, and hopefully they take that into account. They still have to apply the law of Ontario or Canada. They can't apply other laws, but they will take your family's values into account.
Okay. All right. So the last question I have for you is, how do I know if mediation is right? Right. Like, when should I seek mediation services versus taking my spouse or whatever to court?
Okay. So you should speak to a lawyer about that. There are times when mediation is not appropriate, and those are cases where you've got a serious power imbalance and can't be corrected by having lawyers there. It's not necessarily appropriate if you've got someone with mental illness, because there's no point in going someplace and having the other person be crazy and threatening or just off the wall the entire time. There's no real point to that. If there's serious substance abuse issues, you can get into the same thing. Things don't go well at mediation because the other side is not able to comprehend what's going on and not able to control themselves. And there may be other things that make something bad for mediation, that there may be particular legal issues that are so undecided that you need someone to decide that for you. But you only know that if you go to a lawyer. And you only know if mediation is safe for you if you go see a lawyer who you speak to and that lawyer makes you feel confident that you can either go to mediation by yourself or that that lawyer will go with you to the mediation and they will make sure you're safe at mediation. So starting off with a lawyer at the beginning will let you know whether mediation is right for you. And if you pick a lawyer who does advocacy at mediation, which means a lawyer who goes to mediation instead of always going to court, then you'll get a good feeling for whether or not mediation as opposed to court is the right choice.
Okay. And actually, just because you said that, is it something, if you typically go to a lawyer and ask if, I mean, does that normally come up in a conversation, or is it something you have to ask the lawyer, right? Can we try mediation opposed to going to court?
A good family lawyer, when you speak to them the first time, will tell you what your options are. Court is one option, mediation is one option, arbitration is an option, collaborative practice is an option, straight out negotiation is an option. And at your initial meeting with the lawyer should go over all those options for you because they make big differences on how things are decided and what the result is, and they make a spectacular difference as to cost. So if the lawyer you're seeing does not give you the full range of options and explain which one is good and which one's bad for you and how it might unfold in your situation, then you need to see another lawyer who does explain that to you, because it is important that you understand your options going through a separation or a divorce and you feel confident that you're picking the right path.
Okay, great. Well, John, thank you very much for being on the show today. Again, very informative. We hope to have you back again. And for anybody who has any family law issues at all, I encourage you to give John a call. His contact number will be showing on the screen when you view this. And until next time, to your success.